Saudi Arabia officially introduced first bespoke maritime law. The ambition and project set out in Vision 2030 to make Saudi Arabia a logistic and maritime hub necessitated the expansion and regulation of the maritime industry. The issuance of the first bespoke maritime law indicates the importance of the maritime sector to Saudi Arabia's economy and development plans, and is a significant development in regulating the sector. In this article, we look at some of the key issues covered by the maritime law and what it means for Saudi and non-Saudi vessels. In January 2019, the Kingdom of Saudi Arabia introduced for the first time a bespoke commercial maritime law issued pursuant to Royal Decree Number 33 and published it in the Official Gazette on Friday, 4th January 2019. The maritime law came into effect on 3 July 2019. The maritime law applies to all Saudi Arabian flagged vessels and foreign vessels that call at the kingdom's port and territorial waters. The maritime law doesn't, however, apply to warship and public vessels which have been allocated for non-commercial purposes. Previously, maritime issues were dealt by the Commercial Code Law, which was published in early 1931 and was based on the Ottoman Commercial Code. The maritime section of the Commercial Code Law were brief and arguably not suited for modern-day shipping. As of 3 July 2019, the section of the Commercial Code Law relating to maritime issues were repealed, as were other laws of the kingdom that conflict with the maritime law. All maritime issues are now regulated by and are dealt under the maritime law. The below are some of the key issues covered by the maritime law. Nationality or flag. For a vessel to acquire Saudi nationality or flag, it must be registered in one of the kingdom's ports and wholly owned by a Saudi national or a company that is 100% owned by a Saudi national. Alternatively, if the vessel has multiple owners, the majority of the shares must be owned by a Saudi national. Vessel registration. The maritime law provides that any self-propelled vessel shall not fly the flag of the kingdom unless it is registered in accordance with the maritime law and in its implementing regulation, which are scheduled to be issued imminently. However, the below vessels are exempt from registration. Vessel less than 24 meters in length. Fishing vessel whose tonnage doesn't exceed 30 metric tons and which are not more than 20 meters in length. Recreation and diving vessel whose tonnage doesn't exceed 10 metric tons and which are not more than 11 meters in length, and vessel of primitive construction, sailing vessel and non-propelled marine unit, lighter, barges, and other floating structures that normally operate within a port. Non-Saudi vessel. Non-Saudi vessels are allowed to undertake towage, pilotage, supply services, and coastal transportation activities within kingdom's waters unless an exemption license is obtained from the President of the Public Transport Authority, the PTA. This provision is quite significant as it applies to all offshore support vessels, OSV, the majority of which operating in the kingdom are not Saudi flagged. The impact that this provision could have on a OSV owner that is in breach of the same or who doesn't obtain the exemption certificate from the president of the PTA is potentially quite significant from both a financial and commercial perspective, including the owner might be fined between 2,000 and 50,000 SHR. The OSV might be detained, although this is not provided for in the maritime law, and the OSV might be refused clearance to leave the kingdom's waters. Limitation of liability. As per the maritime law, the liability of the owner of the vessel shall be limited pursuant to the limitation of liability in International Maritime Convention to which Saudi Arabia has acceded. On 6 April 2018, the kingdom acceded to the 1976 Convention on Limitation of Liability of Maritime Claims and to the 1996 Protocol. Although the 1976 LLMC and the 1996 Protocol have yet to be enacted via a royal decree which gives laws the status of a statute, the maritime law arguably gives them the force of law or status of a statute, and therefore any limitation of liability should be calculated as per the 1996 Protocol. Limitation of liability is generally not allowed under Sharia law, which is the overarching law of the kingdom, as one of the basic principles of Sharia law is that one should compensate the other fully in respect of the harm that one has caused to the other. The basic law of the governance of the kingdom provide Article 1. The constitution of the kingdom is the Quran and the Sunnah of his Prophet. Article 7. Rules in the Kingdom of Saudi Arabia draws its authority from the Quran and the Sunnah of his Prophet. Article 48. The court shall apply in cases brought before them the rules of the Islamic Sharia in agreement with the indication in the Quran and the Sunnah, and the laws issued by the ruler that do not contradict the Quran and the Sunnah. Therefore, where a law contradicts Sharia law, the court should apply Sharia law as Sharia law prevails over any other law of the kingdom. Accordingly, it remains to be seen if the court of the kingdom will apply the limitation of liability as per the 1996 Protocol or at all. That said, the court of the kingdom have previously upheld limitation provision in bills of lading on the basis that the parties are free to contract and did expressly negotiate the said provision. Should the Kingdom Court enforce the 1996 Protocol, this will see a dramatic shift in the kingdom liability regime and will be a fundamental game changer for ship owners and operators alike. That said, the Court of the Kingdom have previously upheld limitation provision in bills of lading on the basis that the parties are free to contract. Accordingly, it remains to be seen if the Court of the Kingdom will apply the limitation of liability as per the 1996 Protocol. Thank you.